Houston, Texas, every Tuesday at 5 p.m. Central Time, we do bring on immigration updates. Now, Rebecca, what do we have today to discuss?
Yeah, so we're going to go over a few topics, including USCIS site visits for pending I-485 applications, which seems to be a new phenomenon. We've never really heard of that before, so we'll discuss that. We'll also go over do's and don'ts for advanced parole, traveling while the I-485 application is pending, based on some also recent updates that we've seen. Marijuana dispensaries. We've discussed kind of the consequences of marijuana possession and use on the immigration process in the past, but even it seems like even entering a dispensary or a store can be a problem or jeopardize your status, so we'll go into that. And then we'll also discuss these Indian Penal Code cases under 498A, the Indian Dowry cases. We'll discuss those and how to handle them. So it looks like first for the I-485 site visits, Rahul, are we actually seeing USCIS visit employees for the I-485?
Yeah, I've seen that. It's very rare that we have never seen that USCIS having a site visits for the 485. Yes, we have seen them in the H-1Bs. Yes, we have seen them in our visas, but we have never seen them in the 485 applications. So we are seeing it, but I'm unable to figure it out why they are doing it though. When I inquired into the actual people who got visited, when they send the information, they only ask the questions which they normally ask them in the interview. The questions mostly related to show you the pay stubs from the time you joined the company, which filed the 485 application, bank statements showing the deposits of the paychecks that they're getting, also about any offer letter from the ABC Inc. And that's very rare to ask the offer letter. It seems more like a 485 interview for me.
Yeah, a little.
Because that's not, and any of the end clients they're also asking details about the employer-employee relationship and how the employer is supervising. So that's definitely a news to me. I am thinking, Rebecca, the reason why they're doing the FDNS is they're practically interviewing the people by these contract employees so that they can determine the 485 case and approve the case. Because they're in a hurry to approve and there are no enough officers to approve the case. That's what I'm thinking.
Yeah, potentially. So instead of calling applicants into USCIS field office for an interview, they're trying to utilize these FDNS officers who aren't doing as much, I guess, sending them out maybe to contact the employees personally that way and gather the information.
But what if they're completely not prepared and they feel uncomfortable? Can they refuse to answer the question for the FDNS visits, Rebecca?
Technically, yes. So if you are an I-485 applicant and you suddenly get a visit at your door, at your home from an FDNS officer with questions related to your I-485 application, technically you can refuse to answer. The FDNS website is very clear that participation in the FDNS stands for Fraud Detection and National Security. So it's a unit of USCIS to kind of check for fraud, national security issues, but participation by the applicants is voluntary. So you do have the right to tell the officer that you are declining to answer the questions in person at this time. It should not jeopardize your I-485 application. At most, they would just send the request in a written form where you can, go over it in more detail.
Yeah. Rebecca, with regards to the FDNS visits, though, so when these people, you're saying that the website of the FDNS visit clearly says that it's a voluntary program,
right,
and the employees can refuse it, and if you guys were being questioned, no, you have to answer. Refer to them that the FDNS website is very clear that it's a voluntary thing. I can participate, and if I refuse to participate, I cannot be forced to participate. You can tell that if you're ever uncomfortable. The other thing that I suggest you is that we put a notice called AOS, or I-485 interview. We also listed out the documents that you need to take and the information that they're going to ask, the questions that they're going to ask, the mock kind of interview that we went through. Rebecca and I went through that about 3 months to 4 months ago. We want you to watch that. I'm going to put that link by tomorrow in the in the YouTube and Facebook that we have, so that you can go over that link and go over the interview there and go over the process how that goes. Now, it's not exactly the same thing for FDNS, but it's going to be very similar. If you prepare the documents and make it ready for them, it may be very good because you may even get the green card before September 30th, because USCIS officials are very busy. They are trying to do as much as possible. I think so they are using the FDNS to adjudicate more applications and complete the 280,000 target, which in the history of USCIS, they never adjudicated so many employment-based immigrations. And there are not enough people who have knowledge in the field offices to complete the 485 interviews. That's the reason we see that if the person is in Denver, they are sending the file to Tampa, Florida. They're sending the case to LA, Los Angeles in California, rather than having it sending to Denver, which they could have sent it to Denver. Because the officers are not available there, they are sending to different officials to adjudicate this application. Advanced parole, I want to discuss about it, Rebecca. When I get an EAD, that does mean that advanced parole is automatically in it, or is it a different thing there?
Right, so it's important to know the difference between a card that is EAD only and an EAD AP combo card. So not all EAD cards are usable as an advanced parole document. It can only be used for advanced parole if at the bottom it's endorsed with the serves as I-512L advanced parole. So that is printed at the bottom of the EAD, then you can use that as an advanced parole. If that is not written on the card, then it's an EAD only. It can only be used for work authorization. If you file the I-765 and I-131 together, then most likely that means the I-131 is still pending until you receive some kind of update on the I-131 case. If it is approved, the I-131 is approved separately, then the advanced parole document you'll receive is a full-page document. It looks more similar to an I-797 approval notice. It's on that kind of thicker paper, and it also says I-512L on it. Then that one-page document becomes the advanced parole travel document if the I-131 is approved separately.
Rebecca, we are noticing some RFEs right now where the USCIS is issuing an RFE saying that if you have traveled in an advanced parole that has been approved while you're outside the country, they may not approve your green card. Can you explain what these RFEs are about? Right.
So generally the rule is that if you have an I-485 application pending, and if you depart the U.S., while that is pending, you should have an advanced parole approval in hand before you depart in order to not abandon the I-485 application. There is an exception to that rule for people in H or L non-immigrant status. If you don't have the advanced parole approved at the time you depart the US, but you are in valid H or L status, and if you then return to the US in valid H or L status, you are not considered to have abandoned the I-485 application, even if you don't have the approved advanced parole. So the past few years, what we have been noticing is that USCIS, sometimes, not always, while the I-131 advanced parole is pending, if the applicant departs the US, then I would say about a little more than half of the time, USCIS denies the I-131. If they're aware that you departed the US while it was pending, they will deny the I-131 application. And then if you're coming back in H or L status, it's not a problem. You just refile it when you come back. In some cases, though, we're seeing that USCIS still approves the I-131, maybe while the applicant is outside the US. Maybe they were intending to come back in H-1B status, and so they started the process of applying for the H-1B visa renewal at the consulate, because that takes a very long time. Maybe they heard from someone back home that, oh, your advanced parole was approved. Maybe their attorney informed them your I-131 was approved, and then someone mails them the advanced parole card, and they use that instead of waiting for the consulate to process their H-1B visa. If they use that to re-enter the US, we are starting to see now some cases where USCIS is sending an RFE on the I-485 application saying that basically our records show you departed the US while your I-485 was pending, and at that time you departed without a valid advanced parole document. Basically, you know, show us how you have not abandoned the I-485 application. So we are only seeing them in a few cases so far, but these are the first time we're seeing this particular situation, it is a bit problematic because technically that's correct. The rule is that you're supposed to have the advance parole in hand at the time you leave, or you're supposed to come back in valid H or L status. So people in this situation, they don't have either of those situations. But also at the same time, USCIS approved the I-131. They issued the advance parole, and the applicant used the advance parole, kind of in good faith. If they weren't supposed to use that advance parole, why did USCIS issue it?
But what if they deny the 485 application? I know you're making an argument.
Yeah, that is definitely, if you are on the receiving end of one of these RFEs, I would say the best argument you can make is that you intended to come back in H-1B status, H or L status, maybe provide proof that you had started.
But what about the people who are intending to travel and they're expecting, okay, after they travel, they get an advance parole? What do you suggest to them, though?
Yeah, so definitely for people who are not, at the other end of this situation yet, we would definitely recommend don't travel unless you have the advance parole in hand, or if you do, only plan to come back using your H status or L status, even if that means waiting for a very long time for the consulate. Even if that means while you're waiting at the consulate, you get notification that your I-131 was approved and that you have this advance parole. It's tempting to use this advance parole to just come back to the U.S. quickly when, the situation at the consulate is taking so long. But actually, based on these RFEs that we're seeing, our recommendation now is to not do that. If your I-485 is pending and you're departing the U.S. without a valid advance parole, then you should plan to definitely come back in H or L status only. Anything else
you suggest on that?
Yeah, I think that's about it for the advance parole.
I want to discuss about the IPC, this Indian Penal Code 498A section. It's called Dowry case, where the bride can file a I-498A section in India. Most of the people who are from India, they're familiar with this 498. So if the lady files a 498A section, the dowry case, even if you have taken the dowry, even if you're not taking the dowry, they're going to just arrest you, they'll put you in jail for a night, and they will put your mother, they'll put your dad, they'll put your sister, they'll put your sister's husband in jail for a night, and then you will be granted bail based on the circumstances. This is very commonly, even if there is a small dispute between the wife and husband, the wife can choose to use this 498A section in India. We are very familiar. We want to explore more on those things, though. So I want you guys to consult an Indian lawyer first. If anything that happens, not me. I mean, I'm an Indian lawyer. I don't practice Indian law, but I am a licensed Indian lawyer. I definitely want you to contact the lawyer in India who's practicing criminal law there, who's familiar with these things. That's the number one thing. What you guys need to be careful is that when you apply for non-immigrant visa, though, you are supposed to mention that, because in the DS-160 form, they ask a question: have you been ever arrested, cited, or charged with any crime? In this particular 498 case, that you are already been charged with a crime, so you're supposed to mention that one in there. That's one thing that I want you to be careful. A lot of these cases, what happens is that the bride might also put a hold on your passport. That means that you cannot travel. Unless you got a bail, then you can travel. If you did not get a bail, then they will put you on an absconding thing. So whenever you're trying to enter into the airport and trying to fly, there'll be a lookout thing on you, and they will detain you at the airport. Be careful. You need to check with your criminal lawyer on that thing. What happens when a person is in United States, for example, and you're being charged with 498A case back in India, your passport extension may be denied. That's one thing that they can do. The other thing is that when you travel to India, since there is a lookout on you, as soon as you land in the airport, they will detain you. So it's better that you coordinate the matter with the criminal lawyer in India to make sure that when you land, You don't want to land in a wrong airport. For example, if you land in Mumbai and your airport is supposed to be Hyderabad, then they'll detain you in Mumbai and they'll make you fly from Mumbai to Hyderabad, and then the detention will go on much longer time. There are some anticipatory bail that you can obtain it before you go. That's one thing that you need to, and you need to understand the consequences before you go. So if there is anybody, remember that it can be charged against the husband, it can be charged against the father-in-law, mother-in-law, it can be charged against sister-in-law, and it can be charged against the sister's husband. That is, bridegroom's sister's husband also can be detained. So be careful on these things before you do. Now, when you apply for the green card, you are supposed to mention this one. When you apply for the non-immigrant extensions, especially the H4 extensions, most probably the spouses of the sister-in-law, brother-in-law, they when they apply for extension, they are supposed to mention this on the I-485 application. So whenever you've been charged or you're going to fall into that particular criteria, the father-in-law, mother-in-law, or that is the sister-in-law. When I say sister-in-law, that means the husband's sister and the husband's sister's husband. They're all in big danger though. So if you fall into that criteria, even if it's been filed on your brother, you need to be careful. If you are on the list, you don't know whether you're on the list or not. You need to hire a criminal lawyer in India. Make sure that everything is taken care of. Don't just go fly to India. Don't just try to apply for the visa without knowing what's in there in the complaint though. Sometimes where we have the complaint is made, you think so no action has been done. Sometimes they may do the action you don't know, and then you'll be in great danger. It'll be better that you hire a criminal lawyer in India and follow the directions of that criminal lawyer, and also have a consultation with an immigration lawyer here in the United States to have a better idea of what can be done before you take any further steps. You want to go to the questions? Unless you have any things.
Yeah, so we were also going to discuss kind of just warning about even entering marijuana dispensaries while you're in the immigration process. So we have discussed in previous sessions that even though marijuana use is legalized in a number of U.S. states, according to federal law, it is still banned. And
what are you speaking, Rebecca? When I went to Portland, Oregon, there are marijuana stores every street. Mm-hmm. You mean to say these non-immigrant status people and green card holders cannot even enter into those stores?
So under federal law, it is still a banned substance, and immigration falls under federal law. So it can still jeopardize your non-immigrant status. It can jeopardize an adjustment of status application. Even if you're a green card holder, it can jeopardize your ability to apply for naturalization later, because it is still considered a criminal offense to use or possess marijuana under federal law. And that's what
you said, use or possess. Can I not enter with a friend in a store?
Yeah, that's a good question. So technically, if all you're doing is entering the store, you're not purchasing, you're not using, anything like that, technically that shouldn't be a problem under immigration law. The issue is that when you are entering dispensaries, you usually have to provide a form of identification, like your driver's license. And it may get scanned into a database.
Actually, I was being told that it gets scanned into a database.
Okay, yeah. So if it's scanned into a database, that and we know that the immigration agency, the consulates, they do have access to kind of local law enforcement databases. We're not sure to what extent or the extent of the cross-checking, but for example, if you've got a DUI in a small town in Texas, it could result in your visa being provisionally revoked by the consulate. So there is access by the consulates, USCIS, the federal government, to even kind of local law enforcement databases. And so the same for when your ID is scanned into a database that shows you entered a marijuana dispensary. The U.S. government, the immigration agency, could potentially access that, could ask about it. That's the main issue.
My question is, if you're not going to use it, And if you're not going to use marijuana, why the damn hell did you ever have to go there into and scan your driving license there and get into trouble and give us business? Is your main purpose to give us business? Well, that's a different issue. I mean, your purpose should not be that. As Rebecca has pointed out, that yeah, you may be exempt, they may question you, you may get out of it, but do you want it? What is that you're trying to get it? I mean, this is not an airline ticket. You're flying from India to here, yeah, or here to there, then you definitely want to get the advice of the immigration lawyer, may need to know whether your travel thing is permitted, not permitted. Those things are definitely advisable, but just goddamn marijuana store, do you need to do that? I would suggest that you do not enter into marijuana store, and if you ever enter into it, I want you to consult an immigration lawyer, because it may fire back at a later date. Be careful on those things. So let's go to the question and answers right now. People are asking questions. Murli Krishna is asking, if the I-131 is denied, can I refile without company attorney? Yeah, I-131, we see the denials very often, especially the I-131s are denied. If if you have traveled outside the country, you can just go to, you can just refile the I-131. You don't have to go with the company lawyer. You're fine with it.
Srinivasa is asking if your I-485 status gets updated to approved instead of something like card to be produced, does that mean anything? No, don't worry about it. If it says it's approved, then that's good news. The case status website is not always consistent. It's not always updated consistently between different cases. So we know if you're hearing from other people that mine was updated like this and I received the card within this amount of time. But if it shows that it's approved, then that means that the card should be being produced shortly. So I wouldn't worry about it at all.
People are asking questions with regards to how many number of green cards are going to be falling into the family immigration, from family immigration to business immigration. At this point of time, we don't know. They're expecting anywhere between 20,000 to 100,000. Previously, our expectation was much higher, but the amount of adjudications that are happening in the consulates, when we see that, it's a lot of adjudications that's going on there. So definitely we do not have a clue right now, but it definitely will not be 140,000. It will be way, way less than 140,000.
Ashok is asking, where should I send my medical exam if my I-485 is with the National Benefits Center, and that it's, his lawyer is saying that there are so many offices kind of associated with the National Benefits Center, you can't be sure where to send it. That is kind of correct. If your case, the transfer notice just says that your case was transferred to the National Benefits Center, it could be with the main service center there, or it could be with any number of field offices that the National Benefits Center may have transferred it to. You usually do not get a transfer notice alerting you that your file has been moved to the San Antonio field office, for example, but it still kind of falls under the NBC in that case. So it's true, you're not sure exactly where to send it. We are still encouraging people that if you know you have not submitted the medical exam yet, but your I-485 is eligible to be approved, meaning priority date is current, underlying I-140s are approved, and it's been transferred to NBC, we're still encouraging people, if you don't mind potentially paying for another exam, to go ahead and send it in to the main address of the National Benefits Center. I believe it's in Missouri. You can't really send it to a field office if you don't know which one it's at, but if you send it to Missouri, there may be a chance that it could get matched up with a file there. Worst case scenario, if it's not, then you'll get an RFE and just have another copy of it ready, of the medical exam ready to send in response to the RFE as soon as you receive it.
Mohammed Ali has this question from YouTube. Should we submit the medical form along with the I-485 or should I submit it at the later stage? We strongly recommend at this point of time to submit it with the I-485. Of course, back in September, October 2020, we may have recommended just file the damn I-485. I'm sorry, that's exactly what we told them at that time. The reason is that we just wanted our application to be in there at that point of time. But right now, submitting with medicals is the best option that you have. Minot 100 from YouTube has this question. Can I start the C corporation while my 485 is pending, but EAD is approved? If yes, can I self-employ myself in C corporation? The technical answer for you is yes, we can do that. But the problem here that you need to understand is that you will be scrutinized much more. I mean, if you look into the website of the USCIS, it clearly says that a person can be self-employed and the person can still self-sponsor for the 485J supplement and still get the green card if the person is working in a similar profession though. But if ever you do that though, we recommend that you take a lawyer with you. And that's exactly what I don't want to do, is getting the lawyer involved unnecessarily when I don't need to. Is that it's going to be a lot more scrutiny. There are cases we went to the interview and all, I can't imagine any case that got denied, but it took a while for us to convince the officer, look officer, it's very clear that they can work self-employed as long as they're in the same profession. There are times when we had the spouse open a C corporation and got the 485J signed and got the green card approval too. But the scrutiny is more higher. One thing that I want to tell you is that there is called C corporation and there is called S corporation though. To understand the technical tax concept of it, I want you to check with the CPA. I'm not the authority of it, but I'll tell you a simple what happens in C corporation. Let's say C corporation makes $100,000 profit. C corporation, let's say I own 100% of the company. So C corporation earns $100,000. It pays $20,000 as a tax. And what's left over? $80,000. I take the $80,000, then I pay taxes on the $80,000 again. Now what happened? I'm paying double the taxes on the C corporation. When it comes to the S corporation, it pays zero taxes. So $100,000 will come to me, then I'll pay taxes on the $100,000. So there's only one-time tax. And this is where the CPAs get confused though. Can a H-1B, can a EAD person, can a H-4 EAD person, can they be the shareholders of S corporation though? Now, C corporation, anybody can be the owners of the C corporation. Your uncle in India, your grandmother in India can be the shareholders of the C corporation. When it comes to the S corporation, the definition says only residents of United States can be the shareholders of the S corporation. This is where the CPAs get confused. Oh, residents of United States means green card holders. No, not in the IRS definition. When they are defining the S corporation, they should look into the definition of the IRS, not immigration though. In the IRS definition, H-1B comes, EAD, the 485 EAD comes under the residence. Now, F-1 student visas don't come. That's the reason they don't pay Social Security taxes. You, on a 485 EAD, your spouse, who is a 485 EAD, they are considered to be residents of United States. They can be the shareholders of the S corporation. So if you or your wife were to start a corporation, I would want you to start a S corporation, not a C corporation.
Gunjan from YouTube is asking, can his I-485 be approved at the Nebraska Service Center without having been transferred to the National Benefits Center? And he already responded to an RFE on the medical exam last year. So far, we have not really seen direct I-485 approvals coming out of Nebraska or Texas. I believe there's
not in the past 3 months.
Yeah, they're coming out of the National Benefits Center. So if your case is still at Nebraska, so far we're not aware of a way to really request USCIS to transfer the file. The main thing that you can do on your side to make sure nothing is holding up your case from being transferred is to ensure that your medical exam is submitted, which in this case it is. Also, make sure that the underlying I-140 is approved. So that means the EB2, if you interfiled to EB2 or filed a new EB2, as well as the EB3 I-140. If that was what your original I-485 application was filed based on back in 2020, even if you have interfiled now or transferred the underlying basis to EB2 now, if your underlying EB3 I-140 is still pending the downgrade, we're recommending that you still get it approved as a way to try to move it on to the National Benefit Center. And so you can do that by upgrading that EB3 I-140 to premium processing, even though it's not what your I-485 is based on anymore. That may be one reason why it is still at Nebraska or Texas.
Praful has this nice question. His 485 has been transferred to Kendall Field Office on August 2nd. Can we still expect the green card before September 30th? Very good chance. I mean, very good chance. If I were you, if it's been transferred to field office, I'm going to buy a champagne and keep it in the refrigerator. Only for you, Praful. Okay, only for you, Praful. If you don't get it, the champagne is on me. Only for you, not everybody, guys. Only for you. Good chance you're going to get it by September 30th. Okay, only for you. But don't buy a costly champagne, okay? I don't drink costly champagne, so it's $15 is the limit.
Vijay is asking about his I-485 cases. It sounds like he filed back in 2020, then interfiled it to EB2. In addition to that, he refiled in EB2. So he has two I-485 cases pending right now, both at the National Benefit Center, and is asking whether one will interfere with the other. We don't think they will really interfere with each other. At most, what we've seen in some cases is if you have two separate I-485 applications that are pending and you entered your A number on both applications, it seems like they do try to match up files if they show that, you know, based on the A number, you have another file somewhere in the service center. So they may try to match it up, but it shouldn't really interfere with each other. I would say that your interfile case is more likely to be approved sooner because the refile case sounds like it was submitted at the end of June, and USCIS has stated that their goal, the applications that they are targeting to approve by September 30th are the eligible I-485 applications that have been filed and pending since early June 2022. So your first I-485 that was filed probably back in 2020, if it was transferred to EB2, you know, at any time, then that would fit the criteria for the applications that USCIS is targeting. So my guess would be that application is more likely to be the one approved by September 30th.
Life Coach Nitin from YouTube has a very good questions. Could you please let us know what are the basis we are seeing RFEs and medicals? Current patterns, they are filed 485 in 2020. With the medicals, they're still seeing an RFE. Good question. I mean, this is a common question. I mean, everybody need to learn about it. Is that the medicals are valid for a period of 2 years at this point of time. That means that they're still valid until October of 2020. And what's the reason is that in October of 2021, they came up with a new rule called, have you taken the COVID? Now, please, all the people who have filed before, you don't have to do the COVID. That's only the ones that were filed after the COVID rule came out. If I believe it, I may be wrong a little bit. Correct me, Rebecca, if you know the date. It's after October 2021 is my belief, though. So if you have filed before, you don't have to have a COVID thing there. You don't have to. And then they came up with hepatitis somewhere past 3-4 months ago. They came up with the hepatitis thing. So if your application was signed in September or October of 2020, you don't need to have these things, though. But the field offices are coming up with the RFEs. Where is the COVID thing? We don't see that. They don't understand that at the time when we filed, and even if it's been filed properly at that time, they don't need it, but they question it. And the same thing with hepatitis. We have seen that, hey, your hepatitis is missing, even though they filed before this particular rule came in. What do we tell our clients when these kind of RFEs come in? Unless there is some physical ailment that is prohibiting you, I want you guys to go get the medicals again. I'm sorry. I mean, I just want you to get it. I know the punching things that happens there. I will bear them rather than bearing the immigration lawyer. I don't like immigration lawyers. I don't want to handle them. I just want to get the green card as fast as possible. I'll bear the doctors a little bit better. It's too much tension. Travel problem, job problem, job change problem, location problem, loan problem. I can solve all these things if I allow my body to be punched a couple of times by the doctor. I am fine with them. And if they are issuing an RFE for medical, That is, I mean, not in your situation though, but in general, it's a very good sign for me. I mean, my green card is just about to come right now. I'm going to buy a champagne bottle and keep in the refrigerator. That's how I am. So I will tell people that even though you submitted, they ask, go get the medicals again. That's a better way. If you want to come to me, you can come to me. You can pay thousands of dollars. We'll argue until your last blood. Okay? And that's what we are. But I recommend you don't do that.
Aryavan from YouTube is asking about his use of Day 1 CPT in the past. He got the H-1B change of status successfully approved and is asking, can the Day 1 CPT still be a problem at the AOS stage later? I don't think we've seen too many questions about use of the Day 1 CPT programs at the I-485 stage recently, but that's not to say that it can't come up. So we do know that it is still a problem. It can still definitely be a problem at the consulates. It can be a problem at the border. There are 221Gs being issued by the consulates where the only documents they're asking for are the I-20s. And if that's the case, most likely they're going to ask about your use of Day 1 CPT. So we know that the government does not consider the use of Day 1 CPT technically, a valid use of the F1 visa. The F1 visa is meant for students whose primary purpose is to be in the United States to study. CPT, or curricular practical training, is supposed to be a supplemental work authorization given to F1 students who need work authorization because their degree program requires as an integral part of the curriculum a certain work experience component. So a classic example of that is nursing students who have to complete a certain number of rotations in a hospital setting in order to pass, a certain semester or year or course as part of their nursing program. That's kind of the situation that CPT within the first year of the degree program is meant for. It's really not meant for these situations where you just enroll at any time of year in the school. They give you work authorization from day one. You only attend classes
6 days per year.
Yeah, for a long weekend a couple of times in the semester, and the rest of the time you're working essentially. That is not really what the F1 visa is meant for. And a few years ago, USCIS was kind of routinely sending requests for evidence whenever an H-1B change of status application was filed for someone who had used Day 1 CPT. So it's true that we are not seeing those particular RFEs quite as much. And so you may have gotten the H-1B change of status approved successfully, but just recently I saw a 221G where this was the main issue involved, the use of Day 1 CPT. So if that is the case and the consulate denies the H-1B visa, that leaves you with almost no options for coming back to the US. Also at the border, we've had situations where people successfully got the H-1B visa, but were basically turned around at the border by Border Patrol if they saw that there was use of Day 1 CPT by some of these kind of schools that are very well known to the government. The government is aware of these schools that issue Day 1 CPT. They have them on their radar, and it is somewhat a flag. So even though currently we are not seeing it in I-485 adjudications, we know that these schools are on the government's radar. And so our recommendation, if you haven't used it, is to still avoid it if possible, because once you use it, there's really no way to go back and undo it. It could follow you through, consular appointments, border crossings, potentially later at the I-485 stage.
Puru got his EB3 green card 485 denied without any RFE. I'm very happy for you, Puru. He got his EB2 approved a month before, and later on his EB3 got denied. That's an actual story, guys. I'm happy for him. No, Puru, you don't have any problem. Since you got your EB2 approved, then your EB3 got denied. That's a very normal process. You're good to go. You don't have to come every week here now, but once in a while visit and keep writing the letters that we draft for you, okay? And because we still need other people to get the green card. You will have any problem for citizenship. It's a perfect denial. You don't need an EB3. You're good. You're good for your life. Weasley has this question. Rahul, you always say that transferring to NBC is a good thing. What exactly happens there, and what's the advantage in the transfer? As Rebecca was pointing out before, Nebraska and Texas Service Center, these are the two places where the 485s have been pending. They don't adjudicate, they don't approve the 485s anymore unless they've already opened it and they already worked on it. They don't approve it. So if they don't approve it and your case is pending with Texas or Nebraska, how good is it for me? I mean, I don't want it. I want my green card to be approved. So for the green card to be approved right now, your green card has to move to National Benefit Center. Now the question, once it is moved to National Benefit Center, what will happen? There are some officers, some, not many, there are some officers there in NBC that can approve the 485 application, or they can transfer, which is happening in most of the cases. They're transferring it to the local office. The local office is, let's say, Houston, Dallas, San Antonio, and there are a lot of different districts. And New York has many different offices. Those LA, Tampa, that's what we say mostly. LA and Tampa is one of the places that they go. So they transfer to these local offices. The local offices will review the application. They can either grant the green card by themselves or they can call the interview though. In general, we are noticing that previously there was about 20% of the people were getting the interview. Now we are noticing about 5 to 6% of the people are getting the interview. Most of the people, especially the people who are getting the interview, are either criminal record or something that's there. Not all the people, but most of the people have some issues there that they need to be interviewed. That's happening. Only 5% of the people are getting interviewed right now. So that's the process that goes from National Benefit Center. They can approve it, send it to the local office. And local office doesn't have to be your local office. For example, if you're in Atlanta, they can still send your file to Tampa office. Because wherever the officers are vacant, wherever the officer officer says, cling, I don't have work, send me some work, they will send the work to that particular person. And that person, then officer will adjudicate your application.
We have a question about an alternate wage survey, if it can be used for an H-1B LCA, the Willis Towers Watson report. So our office has used wage surveys from Willis Towers Watson before. It's fine for the LCA. It hasn't been a problem. In our experience, it still gets processed within the 7-day turnaround for an LCA, and then you actually don't submit that wage survey. You're not required to submit it to USCIS, but you do still need it on file. So that one is fine for an H-1B LCA. We were using it primarily, I would say, at the end of last year during that period when DOL was trying to revise the wages, or the year before when DOL was revising the wages much higher than they were before, and we were going to alternate wage sources for LCAs for perm applications. One thing that I do want to note is that although for H-1B LCAs, alternate wage surveys are not a problem, it does result in quite a much longer processing time for the prevailing wage determinations. So even a standard prevailing wage determination, as we've mentioned on here before, that is already taking about 6 to 7 months. If you are using a non-OES survey, basically a private wage survey, that could add another 2 months to the processing time. This is also a relatively new phenomenon that we've noticed just this year, that we saw private wage survey based PWDs are taking about 1 to 2 months longer. So that is definitely something to keep in mind if you are looking at that as the basis of your perm application. In addition to that, there have been a few cases where we've seen the DOL officers basically reject the private wage survey at the prevailing wage determination stage. This is for perm, not for H-1B. They basically, after 8 or 9 months, issue the wage determination, but they still used the OES wage survey. They just decided not to use the private wage surveys. So it added additional time. They ended up not going with the private wage anyway. So that's kind of something that you may want to keep in mind, or your employers to keep in mind when deciding how to proceed with the prevailing wage determination request.
I just want to add some things to the National Benefit Center, how the process will work is that when they send to the local office can issue an RFEs. That's one thing I forgot. Especially if the medicals are not there, they can issue an RFEs. or they can issue an RFE with regards to having you file a 485J supplement. That's something that they can issue an RFE to. So they can issue an RFE, and once you submit the RFE, they are really adjudicating the case within 2 weeks, most of the cases though. People are asking the questions, we have filed in July, can we get the green card by September 30th? So that's August and September. I'm just going to read the last 2 approvals we got in our office. Actually, we got plenty of approvals on Monday. I mean, plenty. I mean, we got 50 approvals on Monday. That's a lot of approvals for us. One single day. I counted 50. And the approvals that we came had some dates filed in May 19th, May 12th. There are some in April. There are some cases filed in, one case filed in May 25th. So there are cases that are getting approved approximately anywhere between 60 days to about 70, 80 days. There's a possibility you can get the approval. There's a possibility. The unfortunate thing is that if the people who have filed in October to October 2020, they are getting it slow like a tortoise. And these people who filed in February and March, April of 2000, some in May of 2022 are getting the approval fast. Is there anything that Reddy Neumann PC has done special for the people whom we filed in May? Please, we did not. I mean, we didn't do anything special, guys. No, we didn't. There's no magic that we have. It's the same thing happening across all other law offices too. It's just unfortunate that the October or November and December of 2020, there were not enough officers, they were not trained, they don't know how to do I-140 and 485s in there. Most of the applications that we are filing recently actually have already got the I-140 approval. That's definitely a trick. I mean, to get the I-140 approval before you file a 485 is a trick that we learned it, but then back in October, November, or December, that's not how we were looking at it. We just wanted to get our foot in at that point of time because people were waiting for a long time. We don't know how long the prior date will remain current. So things were different at that time. But now, if I get a case, I will wait until I-140 approval comes in, file in premium processing, get it approved, and then do it. But that's not how these things were at that time. And they were not accepting direct premium processing at that time. And as you already know that, we did not file. We filed in regular and then converted to premium processing.
AJ from YouTube is asking about when should he let his previous employer know about an H-1B transfer? Can the old employer still run the payroll after he is transferred to the new employer? So you do have to be pretty careful with the timing of when you are joining the new employer, when you resigned from the previous employer in an H-1B transfer situation. So if the new application, new employer has filed your H-1B as a transfer, as a change of employer, you need to make sure that you are no longer working for employer A at the time that you join employer B. So the only way that you can work simultaneously for both companies is if the second employer has filed their application requesting concurrent H-1B employment. And that is fine if you will be working for both simultaneously for a period of time, as long as the new employer's application is marked as concurrent employment. That is absolutely fine, and we've done other videos on the channel explaining exactly how to do that. But if the second employer's application is marked as change of employer only, you cannot work for both at the same time, and you need to make sure that there isn't any overlap between your end date for employer A and your start date for employer B. Having said that, if you have resigned from your first employer, but maybe due to their payroll schedule, your last payroll with the company won't actually be issued until you've already joined employer B. That's fine. That's not a problem. If the pay date on your last paycheck with employer A is a date after you've joined the new employer, as long as you have some record, it's best to have something in writing with employer A that confirms your last day with us is this. Or you emailing them that says my last date reporting to work will be this, something that confirms what your last date of work is. But then if you receive the actual payroll later, that's fine.
Jitendra Huda has a question: how many of the 280,000 green cards are left? I'm worried if they're already over. No, because we got the September visa bulletin though, and they didn't move the date back. And there are some times they put unavailable. In other words, they won't approve any more green cards in September. I have seen that many times when they completed their quota. Back in the olden days, it was only 140,000. This year, we are lucky. So that is not the case. So there are some things left over. So hopefully, so you will get it. That's my hope. Question with regards to the primary applicant got the green card approved. The dependent did not, but the dependent has an EAD and advanced parole. Can the dependent now travel outside the country using the advanced parole? Absolutely, they can. No problem with it at all. They can travel and come back. There are some cases people ask the question, what happens if while I'm outside the country, I get my green card approved though? The good part about it is that they will still allow you to come on advanced parole, even though you got the green card. And at the port of entry, you may have to spend extra 15 minutes. That's all it is. No problem to anybody though. No problem to anybody though. The other method that people can use is that if you can ship the green card directly to your wife in India, wherever she is at, and she can still carry the green card and come into the country. That's available too.
Awesome from Facebook is asking also an H-1B transfer related question. If his new employer is requiring him to join based on the receipt notice, how does he keep his prior H-1B in case the transfer gets denied for some reason? So as we mentioned earlier, you can't really be working for both employers at the same time unless the second application is filed as concurrent H-1B employment. But if you have resigned from employer A and then start with employer B based on the receipt notice, if employer A has not withdrawn their H-1B approval for you, then as long as that employer A approval notice is still valid, as long as it is not expired, you can always go back to work for employer A without them needing to file anything additional, as long as you're going back to the job on the same terms as the approved application, the same work location, salary, title. Employer A doesn't need to refile anything in order for you to go back to them, as long as they have not withdrawn the H-1B approval that they had for you and it is not expired. So that, you're kind of saving the employer A application in case employer B's falls through. It can be done, but it depends on employer A kind of agreeing not to withdraw the approval even after you have resigned from the company.
Question from John. Does the 485J needs to be approved before we get an RFE from medicals? No. Sometimes, John, they don't issue the 485J receipt note at all. Sometimes they never approve, sometimes they approve. That has no link to it at all for you to get the RFE in medicals. My other suggestion to you is that I want you to interfile medicals, because we have seen in case again and again, if you interfile medicals, you have about 50 to 60% chance it goes to the file and they will approve it based on the interfiling that you do. Rahim has this interesting question, and this is a very common question that we see. Faizam, sorry. We received the green card yesterday, filed in EB3, no upgrade, no downgrade, no interfile, but the priority date is August 2014, which is not current in EB3. What should we do with the USCIS mistake? Well, we see that very commonly, this one. Your final action date was never current, Mr. Faisam. That part I know. My main question to you right now is, did you ever had any EB2 approval with any employer, not the current employer, but with any employer? If that's the case though, what I would do is shut my mouth up and do nothing if I were you. But don't contact the USCIS, please. Don't contact the USCIS. We have done some mistakes like that. The USCIS came back and told us, since your client has an EB2 approval with a previous employer, they have a right to adjudicate in EB2. So I don't want to put any flags in there. Before you contact the USCIS, I want you to contact her, because you may have a EB2 approval with some other company. Also check your green card. Does it say E3 or does it say E2? That's something that you may want to look into though. So it may say E2 based on the previous I-140 approval. Contact a lawyer if you need to, but don't contact the USCIS. And if you contact the lawyer says that I will contact the USCIS, go to the second opinion before you contact the USCIS.
Payush has a pending I-485. He got married earlier this year and his wife just recently entered the US. And he received a few days ago an RFE for his medical exam. And he says his attorney is advising him that he should not respond to the medical RFE until his wife's I-485 application is submitted. So that is true. We would advise the same. Your wife, as long as your I-485 application is still pending and it is not yet approved, your wife can file her I-485 application as your derivative. She doesn't need to go through the family-based process, the I-130, any of that. She can just file the I-485 directly with a copy of your I-140 approval and your I-485 receipt notice, and that's fine. If your I-485 gets approved before her I-485 can be filed with the receipt notice issued, there is a chance that that she will not be eligible for adjustment of status as your derivative. In that case, she would need to go through the family-based process, basically file as the spouse of a green card holder, which could take an additional 2 years at least.
And then if she's an H4, we may not be able to file that adjustment of status.
Exactly.
She has to leave outside the country. Oh man, you don't want that.
Yeah.
One thing is your lawyer is a very, very smart lawyer.
Yeah. Mm-hmm.
He's a very smart lawyer, a very nice guy.
Yeah. Yeah, so that is definitely a very good timing advice. Hold off on your medical RFE because then you know USCIS cannot approve your I-485 until the medical is submitted. In your case, everyone else is trying to get theirs submitted and approved as soon as possible. In your case, you want to wait on your I-485 approval, submitting your medicals until your wife's I-485 can be submitted. So try to get that submitted as soon as possible, her I-485.
Anything else? There are some times we need to be very careful of getting the green card approval, especially if the people are not married, they want to bring their spouses though. We tell them not to file the medicals at all because that's a way we don't want this guy to get the green card. Though. Rebecca, what about the deadline? They have only 30 days to respond to the RFE deadline. Can you explain that? How can they extend it?
Yeah, so any deadline on a request for evidence that you see currently, really you can add 60 days to that date that's printed on the RFE. So ever since COVID, 2 years ago, USCIS has been giving a 60-day grace period to respond to any request for evidence, notice of intent to deny, anything from USCIS that has a response deadline. The printed deadline does not include the 60-day grace period. So whatever the deadline is printed on there, you actually
Do they need to file a request for the 60 days exemption? Okay.
Yeah, it's automatic. USCIS announced recently that they're continuing to extend that policy. So you do have 60 days beyond the printed deadline.
I don't recommend all the people using it, but for this gentleman who has a very smart lawyer, should use that. Mm-hmm. Anything else, Rebecca?
No, that's all.
This is my business partner, Rebecca Chen. If you want to consult her or me at any time, you can make a booking at rnlawgroup.com. I'm going to give a link of adjustment of status interview and the questions that they are going to ask and the documents you need. I'm going to put it out by tomorrow in the link that in the Facebook and YouTube. I'm going to put those things. So if you want to look into that video and look into the documents, please go over those things. Thank you very much.
Thank you.